Under section 58, the facts admitted need not be proved. Admission by parties before a suit are dealt with in section 17. This section deals with admission. 8 are before the hearing. In the case of Mong Po Keith versus Mong Se Bai, 1923, 1 RAN 405, it was held that no proof need be given of a fact which the parties or their agents agree to admit at the hearing, or which before the hearing they agree to admit by writing under their hand, or which by any rule of pleading in force at the time they are deemed to have admitted by their pleadings. In the case of Mong Wala versus Mong She, it was held that every allegation of a fact in the plaint, if not denied specifically or by necessary implication, or stated to be not admitted in the pleadings of defendant, shall be taken to be admitted. The court may, in its discretion, require any fact so admitted to be proved otherwise than by such admission, under Order 8, Rule 3 of a Code of Criminal Procedure. Where a document is not admitted in the pleading but only at the trial in evidence, the document must be proved. In the case of Narendra Kumar versus Vishnu Nair, AIR 1994, Delhi 209, it was held that where at the initial stage of eviction proceeding, execution of agreement of a tenancy showing the other party as a landlord owner was admitted by the tenant, he subsequently could not take the plea that the agreement was obtained by fraud. In a case of in the same case, it was held that the admission in pleading or judicial admission admissible under section 58 of the Evidence Act made by the parties or their agent, 8 are before the hearing of the case, stand on a higher footing than evidentiary admission. The former class of admission are fully binding on the party that makes them and constitute a waiver of a proof. They by themselves can be made the foundation of the right of the parties. On the other hand, evidentiary admission, which are receivable at the trial as evidence, are by themselves not conclusive. They can be shown to be wrong. In the case of Nasim Bano versus State of UP, AIR 1993, Supreme Court 2592, it was held that where averments made in a writ petition were not converted by the respondent, the court said that they should be presumed to have been admitted. In a case of Josna Gowda versus Brundaben Gowda, it was held that an admission must be clear and unambiguous in order that such an admission should relieve the opponent of the burden of proof of the fact said to have been admitted. In a case of Baijnath Singh versus Musamad Birji Kaur, it was held that formal proof of document, even when it is required to be proved in a certain way, for example, by calling a person who have attested it, see section 68, may be waived by any of the parties whose interest it may affect, although such waiver does not affect the legal character of the document or its validity. In the case of Broadway Center versus Gopal Das, EIR 2002, Calcutta 78, it was held that the said that an admission made in an affidavit, unless explained otherwise, furnishes best evidence. The defendant in his affidavit, sworn before the notary public, made an unequivocal admission that he was a member of the partnership in a question, and he retired from it. This was held to be conclusive proof of the existence of partnership and his retirement from it. In a case of Ramaiah versus State of Karnataka, 2014, 9 Supreme Court cases, 365, it was held that the documents produced by the prosecution, though not formally proved, can be relied upon by the defense to falsify the prosecution version. In a case of Ram Niranjan Kajaria versus Shiv Prakash Kajaria, to this extent, proposition of a law that even an admission can be withdrawn, as held in Panchdev Narayan Srivastav versus Jyoti Sai, was observed but was overruled. It was held that a categorical admission made in a pleading cannot be permitted to be withdrawn by way of amendment. In a case of Oriental Government Security Life Insurance Company Limited versus Narsimhachari, it was held that if the court is satisfied that the admission has been obtained by fraud or that there is other good and sufficient cause, it will be discretion under the proviso to require the fact to be proved otherwise than by such admission. Under section 59, proof of the fact by oral evidence. In the case of P. Ram Reddy versus Land Acquisition Officer, it was held that oral evidence has been defined by the Act to be all statements which the court permits are required to be made before it by witness in relation to matter of fact under the inquiry. All facts except the contents of the document may be proved by oral evidence. This section is not happily worded. Contents of the document may be proved by oral evidence under certain circumstances, when evidence of their content is admissible as a secondary evidence. Oral evidence, if worthy of credit, is sufficient without documentary evidence to prove a fact or a title. In a case of Dinomoy Devi versus Roy Luchmiput Singh, it was held that it is a cardinal rule of evidence that where written document exists, they must be produced as being the best evidence of their own content. In case of Mir Ustad Ullah versus Musummad Bibi Imam, it was held that their oral testimony is conflicting. Much greater credence is to be given to men's act than to their alleged word, which are so easily mistaken or misrepresented. In a case of Radhakant Yadav versus State of Jharkhand, it was held that where the body was recovered from a well, but the evidence of the witnesses to the fact of recovery could not be accepted because of the absence of their signature on the inquest, and they also did not support the recovery, it was held that in such circumstances the investigating officer himself becomes a direct witness, and his evidence could not be disbelieved unless there was evidence that he had a motive to create a false evidence. In a case of Ayub Khan Nur Khan Pathan versus State of Maharashtra, it was held that an affidavit is not evidence within the meaning of Section 3 of the Evidence Act of 1872. Affidavits are therefore not included within the purview of the definition of evidence as has been given in Section 3 of the Evidence Act, and the same can be used as evidence only if, for sufficient reason, the court passes an order under Order 19 of a Code of Civil Procedure 1908. Thus, the filing of an affidavit of one's own favor cannot be regarded as sufficient evidence for any court or tribunal on the basis of which it can come to a conclusion as regards a particular fact situation. However, in a case where the deponent is available for cross-examination, an opportunity is given to the other side to cross-examine him, the same can be relied upon. Such view stand fully affirmed, particularly in view of the amended provisions of Order 18, Rule 4 and 5 of the CPC. Under Section 60, oral evidence must be direct. This section says oral evidence must be direct, that is, if it refers to a fact which could be seen. The evidence must be of a witnesses who says he saw it. A fact which could be heard. The evidence must be of witness who says he heard it. A fact which could be perceived by any other sense or a manner. The evidence must be of a witness who says he perceives it by that sense or that manner. An opinion or the ground on which that opinion is held. The evidence must be of a person who holds that opinion on those grounds. This section, subject to the proviso, excludes opinion given at second hand. The use of the word must in the first clause of the section imposes a duty on the court to exclude all oral evidence that is not direct, whether the party against whom it is tendered objects or not. In a case of High Life versus Murari, 1740, it was held that where a person is a witness of a fact, his testimony is regarded as a direct evidence, even if he is not able to recollect the facts with a precision and has to rely upon his belief as to what he saw or heard. A witness who perceived an event with his senses is not confined, when giving an account of it, to what he can swear to with complete certainty or with complete precision. He may swear to the substance or effect of the word used. In a case of Lord Melville's case, it has been held that it has long been established that giving evidence of what he saw or heard, he may swear to the best of his belief if his recollection does not enable him to be more positive and precise. In the case of Taylor, 12th edition, section 570, page 363, it was held that the term hearsay used with reference to what is done or written, as well as what is spoken, and in its legal sense, it denotes that kind of evidence which does not derive its value solely from the credit given to the witness himself, but which rests also in a part on the veracity and competency of some other person. That this species of evidence is not given upon oath, that it cannot be tested by the cross-examination, and that in many cases it supports some better testimony which might be adduced in the particular case, are not the sole ground for its exclusion. Its tendency to protect legal investigation to an embarrassing and dangerous length, its intrinsic weakness, its incompetency to satisfy the mind of the existence of the fact, and the fraud which may be practiced with the impunity under its cover, combine to support the rule that hearsay evidence is inadmissible. According to Stephen's introduction, the word hearsay is used in various senses. Sometimes it means whatever a person is heard to say. Sometimes it means whatever a person declares on information given by someone else. Sometimes it is treated as nearly synonymous with irrelevant. In the case of Sharad Sarda versus State of Maharashtra, EIR 1984, Supreme Court 1622, evidence of witnesses who spoke from personal knowledge of the mental state of the deceased housewife was allowed, but not their opinion as to her nature. Evidence of what the witness heard on the spot of the accused saying to his wife held direct. In a case of Sachit Chandra versus State of UP, the fact that after filing the FIR at the instance of deceased companion, the witness went to the spot and heard people to talk the same thing as was scribed in the FIR was held to be not a direct evidence.